Well, let me first of all thank the University of Vienna thank those who have invited me to this conference. But as I have not very much time and have a lot to say, I just start and go into the middle of what I have to say. I think the more I try to make up my mind on with a view to this presentation, the more I became confused, I must say, overwhelmed by the recollection of the problems, the issues I had to deal with during my nearly 11 years. It's 11 years, it's 2019, I finished, not 2018. Otherwise, I couldn't have done the judgment of the Bagbo, which it was issued in 2019. 11 years tenure at pretrial, as a pretrial judge, but also as an appeals judge and as a trial judge at the ICC. These problems were not only, of course, related to the collection and the evaluation of evidence, collection being more for the prosecution and evaluation more for the judges, but even remaining in the area related to the evidence, it's already in the determination of what is evidence and what is not evidence, which can be used for the establishment of guilt or innocence. The discussions among judges were quite vivid, I must say, and controversial. No doubt that at least partly the problems are rooted in the sometimes very difficult interpretation of the new legal system, which was established in Rome in 1998 by blending the principles of common law and civil law. The two systems, I must say, have not very many similarities. And as I try to explain it to non-lawyers, they have the same starting point, which is the crime, and they have also the same destination, which is a verdict. But the travel route and the vehicle used are completely different to go from the crime to the verdict. So they do not really talk together very much, but nevertheless, in Rome, they tried to make one new system. And of course, this creates problems, legal problems, discussions among judges. But let me also submit, based on my, as said, 11 years of experience inside the court and inside all divisions and chambers, that this new legal system, its interpretation and its application is only one part, an important, for sure, part of the problem when it comes to judicial activity. The assessment of evidence being obviously the core of it. But other two major issues have to be taken into consideration in the context of the work of the court. And I'm warning now you all, I'm not a diplomat and I'm not hypocritical. I try to say things as I lived them. And what I'm going to say now is something everybody in good faith and open-minded with some insider knowledge would agree with, I'm sure. But of course, it's not the mainstream information dispensed by the court or by who is not in good faith. As said, beside a blended legal system, there are other two main factors affecting negatively not only the collection and the evaluation of evidence, but the judicial work as a whole. The first is that the level of a large part of persons working in the court, and obviously I'm referring mainly to the lawyers, to those who at each stage of the proceedings are involved in the decision-making process, are not at the requested and expected standard of professionalism. At least they're not at the standard I had expected them to be when I went to the court in 2009. And not at the standard that, to my understanding, would be needed. Then maybe I'm wrong, could be, but I have some doubts. Many people have never seen it working in there, have never seen a court or a courtroom from the inside. And this is a problem. The second problem I want to speak out clearly is much more difficult to deal with, because the first one you can overcome, okay, but by hiring better people. The second one is a difficult, is an endemic problem. I'm referring to the culture, and the legal culture in particular, the culture in general and the legal culture in particular, of all those who participate in the decision-making process, mainly going from the investigator through the prosecutor through the judiciary. I'm not at all want to say with this that one culture is better than the other, not at all. I don't say even that one should prevail over the other. No, it's not that the problem. But it cannot be denied that this clash of cultures is impacting on the work of the judiciary. And that we should all, the lawyers in there should all try to make a step back from their own culture, not to try to make the own culture prevail over the other, which a little bit is the case. And let me just give two examples, one for the collection of evidence and one for the assessment of the evidence. Abu Garda case, if you're familiar with the ICC case record, you know, the Abu Garda case back in 2010, it was my first case I followed from the beginning to the end of the pre-trial stage, of course. I was a pre-trial judge. It's a case stemming from the Sudan Darfur situation. I have to say, I'm coming from a 24 years prosecutor experience, working experience as a prosecutor. So I was very close to the case somehow, although wasn't being a judge. And I was single judge for the Darfur, nominated by the chamber. When I received the document containing the charges and the list of evidence, which has to be filed in view of the hearing, by reading the list of evidence just on the screen, I had some doubts that, yes, I had some doubts about what the content of this list. I can't remember exactly the number of items, but about 300 items were listed. So I had some doubts, but on the other side, I was new. So I wanted also to learn. Maybe I'm wrong. Okay. So what I did is I asked my team to print all the evidence, not just to look at it in the screen, because I'm an analogical man, not due to my age. So I had to read on paper. And I was well aware that to investigate international crimes was much more difficult than to investigate domestic crimes at the domestic level, which also is not so easy. But nevertheless, I was, and I'm still, and I was during all my tenure, of the very, very strong opinion that there is no trial without evidence, there is no conviction without good evidence, and that the ICC is the criminal court, not a sort of a conviction machine whereby people are found guilty and are convicted based on the gravity of the charges. Well, once printed, the evidence, and at the first look already, confirmed my suspicion. Not all what I would call evidence was evidence, to my understanding at least. So I asked my team to make 3 stocks and to put in one what I would call evidence. I mean, reports of witness statements, police reports, and expert statements and things like this. Okay, what I would say, this is evidence, then we see what's inside, but okay. Then we made a second one with items called evidence by the prosecution, but on which I would never, ever in life base a judgment on. Newspapers, huge amount of newspapers, anonymous statements, documents without any information, you don't know where they came from, what they, everybody could have, but this was in the list of evidence. And then the third one, we put in a sort of a gray area for further assessment, where to put it in one or the other. Well, and like example is the NGO's report. Huh? What is the NGO's report? Is it evidence or is it not? So, well, I see that people are saying no in the audience. They are not, and I agree, fully agree with it, but it's not so clear at the ICC. Well, to cut it short, in the decision declining to confirm the charges, for Abogado, one can read 8 February 2010. The lacuna and shortcomings exposed in the mere factual assessment of the evidence are so basic and fundamental that the chamber need not conduct a detailed analysis of the legal issues pertaining to the merits of the case, in particular as to the existence of the material element constituting any of the crimes charged. I think quite devastating, I must say. The second example is related to the evaluation of evidence. And here I refer to my last case, the Gbagbo and Blegude case, where I presided over for 3 years. But I could make could take as example any other case, the Ruto and Sang and the Katanga and Bemba and others. Just some background information. The case was opened on 31st, in October 2011, with the issuance of the arrest warrant against Gbagbo, former president of Ivory Coast, and defined on 31st March 2021, this year, with the appeals chamber judgment confirming the verdict of acquittal I read out in January 2019. I will not obviously dwell in the millions of issues and problems and discussions. It would be interesting, believe me, it would be very interesting. I directly experienced and witnessed in the case, but I just want to give you an idea of what the blended system, together with the interpreters, the judges of it coming from different cultures, as said before, legal and not only, is able to produce in terms of decisions, and I will limit the decisions only to the three basic decisions in the merits: confirming the charges, the first instance, and the appeals decision. Well, the confirmation of charges, which one would think is one decision, it's not. It's one decision, but there are at least 4 opinions appended to this decision. So 4 judges, 4 opinions, which have their own ideas on the verdict, although at the end they agree on the outcome. Not all, because one was a dissenting. Then you have the trial I was involved in. It's one sentence, acquitting, but 3 opinions. Of the 3, of 1 for each judge, mine as well. One of them dissenting. So we have the same evidence, but 3 opinions on the same evidence. And if you read, oh, well, don't do it, but if you read, at least do only mine, it's the shortest one. But if you read these opinions, well, sometimes you think there are 3 different trials. Huh? Then you come to the appeal, where you have obviously one decision confirming the verdict, but 4 opinions attached to this one decision. 3 separate and 1 dissenting. In sum, in the trial against Laurent Gbagbo and Charles Blé-Goudet, the trial has produced, in 7 years of jail by Laurent Gbagbo, 3 decisions in the merits, and which one would expect. But beside the 3 decisions, we have 11 different opinions by 11 different judges. They all assess the same evidence. The only definition I can think of it is legal schizophrenia. But let me now come to some of the many legal provisions in the statute, which, by trying to combine common law as well as civil law ideas, often seem inconsistent or contradict themselves, giving rise to exhausting discussions among the judges, which obviously is not favorable to the efficiency of the. And one would say, why are you so long? Why does the proceedings take so long? Well, now I give you some examples. And obviously, I just mention a few of them because of the time constraint. I was told I have another 14 minutes, I think. Agreed facts, I just put it as a flash. Agreed facts, Rule 69, is paradigmatic as such for this confusion. The parties, says Article 69, can determine, this is typical common law idea, can determine what has to be considered by the judges as true and as proven by agreeing on facts. And our, Rule 69 says the prosecutor and the defense may agree that an alleged fact which is contained in the charges, the content of a document, the expected testimony of a witness or other evidence is not contested. Well, but however, in the very same sentence of the very same rule, it is stated that the judges are not bound to the agreed facts. You can agree what you want, but the judges are not bound, which is a very civil law idea. The chamber may consider such a fact as proven, may consider them proven, unless the chamber is of the opinion that the more complete presentation of the alleged fact is required in the interest of justice, in particular, particularly in the interest of the victims. So this is one rule with two complete opposing principles inside. And you can imagine in the Gbagbo and Bligode case, we had no agreed facts, of course, because it was the discussions, just leave it aside. Questioning of witness. At the ICC, all cases are, so far, at least until I left, but I can't imagine that things changed, followed the basic common law structure of dividing the case between a prosecutor case and a defense case. And this finds its roots in Article 69.3, which provides that essentially the parties submit evidence. A manifestation and consequence of this is that all the cases so far followed, at least in principle, the formal common law manner of questioning witness. And this means that the case is largely in the hand of the parties. First, the so-called calling party conducts the examination. Somebody would call it direct examination, not me. And the other party has afterward the right to, someone would call cross-examine, but I would not call it cross-examine. I always call it examination of the calling party and examination of the non-calling party, because the word cross-examination is not in the statute. Yes, 5 minutes, no, because he started at 9:05 and at 35, well, 6, 7 minutes. You can have 7. Okay. So the role of the presiding judge in any case is somehow self-restricted in order to find a compromise between the two things. However, this practice could be completely different if you look at the legal framework. Rule 142, not 42, but 42, allows the judge to question the witness themselves at any time they deem to be meaningful. So the principle is again has fallen. Huh? The rules would therefore permit to the judges to exercise a much more active role. They are not just there, they could, if they wanted to, not just sit there as a referee and decide who won the game between the prosecutor and the defense, but they could intervene. And you can imagine that I did intervene sometimes. It's needless to say that my self-restriction was not really very successful, which provoked, obviously, the emails from colleagues from the other system saying, what are you saying? And I said, well, okay. Then witness preparation. What about witness preparation? Can you imagine a witness preparation in a civil law system? No, no way. So I obviously did not allow witness preparation, which was quite a normal thing in other, or was it, no, is a normal thing in other chambers. When I saw the witness preparation protocol they submitted to me and I rejected, well, and I read things like expected evidence. What is the expected evidence? The truth, the only expected evidence is the truth, not the evidence you have prepared the witness for. And what is a hostile witness? The witness has to say the truth. It can't be hostile, or it's true or it's not true. This is not hostile, and then you can fight a better fight. I'm really going fast. The testimony of the accused to a civil law lawyer, it's blasphemy. I don't know. It's something you cannot think about. How can a person who is accused testify for himself and for his innocence. It's not thinkable. In in the civil law countries, the accused can lie, is allowed to lie. And when I started the trial, I was faced twice with this problem. One time in the Kenyatta case, where luckily in the chamber we were 3 civil law judges. So we said, okay, you can testify under oath. So Kenyatta, today's president of Kenya, he went out, he was sworn in, and he said something. But he agreed before that we will keep it not as a testimony under oath, but we would treat this as a unsworn statement. So luckily we were 3, so we did not dwell into big discussions. But I had before starting the trial in the Bagbo case, I was faced with a decision which was issued by the chamber before I was part of it on the conduct of the proceedings, which said, if an accused elects to give evidence on his own behalf, he will be subject to the same rules applicable to other witnesses, including the requirement to give a solemn undertaking and to be questioned by the parties, by the other parties and the legal representative of victims. Luckily, the issuance of the directives fall explicitly in the competence of the presiding judge. So I changed this and some others, which obviously gave rise again to big internal discussions, but I didn't allow not even the potential. Now I'm finishing. It's terrible. So I will not talk about victims' participation, which is another huge issue, but we can talk about it later. And I come to the conclusions. I am an optimist. Maybe it doesn't, I don't look like it, or maybe I look like it, but what I said, it doesn't look like it. And by speaking out loud what many think, I just want to kick off on an open and sincere and open discussion on what is wrong at the ICC. We cannot just say here everything is nice and fine, and this is the main and keeping in mind this mainstream judgment about the ICC. It is not. A first positive element I can see is the election of Karim Khan as prosecutor after LMO and Fatou Bensouda. I think it's the first step in the right direction, because Karim Khan, I know him very well. He is really an excellent person, an excellent lawyer. He was a defense lawyer. He was the president of the ICC bar. So I really hope he has the strength to do what he wanted for sure to do by accepting to be after his election. But, and here I come also to that what the title of the conference suggests, I think in parallel to the ICC, I think that the increasing of the international crimes, of the judging of investigating an international crime before domestic courts would be for sure extremely positive in order to not to leave all the heavy burden on the ICC. Thank you very much.